Hello and welcome to our video discussing the recent Amazon state aid ruling delivered on December 14, 2023. So this decision, it upheld the General Court ruling of 2021, which had absolved Amazon from paying Euro 250 million in back taxes and also raises critical questions about state aid enforcement and tax competition in the European Union. So to give a brief overview, the Court of Justice of the European Union rendered its judgment in the European Commission's appeal against the May 12, 2021 General Court of the European Union judgment in Luxembourg and Amazon versus Commission. The CJEU upheld the General Court's judgment despite finding certain errors in the General Court's reasoning. According to the CJEU, the European Commission's decision had to be annulled in any event because of the incorrect determination of the reference system rather than for the reasons given by the General Court. So this is an important ruling in the series of the state aid rulings. In this, the CJEU ruled that the General Court was justified in determining that the European Commission did not prove the granting of an advantage to the Amazon group. So just to give you a brief idea on the facts of the case and the structuring which was under discussion in this case. So Amazon European structure included two companies. Lux SCS held the intangible assets, while the Lux OpCo operated the online retail business. And Lux OpCo paid royalties to Lux SCS for using intangibles. So Lux OpCo was Amazon EU SAL, and the royalty was being paid to Amazon Holdings Technologies. The European Commission investigation, it related to rulings that the Luxembourg tax authorities had issued in 2003, which had confirmed the arm's length nature of royalty payments that Amazon EU SAL paid to Amazon Holding Technologies. In October 4th, 2017 decision, the European Commission concluded that the tax authority rulings granted state aid because they set a transfer pricing result and methodology that is not in line with the arm's length principle. So the EC decided that the royalty paid was excessive and did not reflect the economic reality of the functions performed by each entity. Now, the EC calculated a lower royalty using a different method and also concluded that the tax ruling conferred a selective advantage to Amazon and therefore constituted unlawful state aid. So the EC ordered Luxembourg to recover the aid from Amazon. Now, subsequently, Amazon and Luxembourg, they challenged the EC's decision before the EU General Court. So on May 12, 2021, even the General Court annulled the EC's decision on the basis that the EC did not sufficiently demonstrate the existence of a selective advantage. So post the annulment of the EC decision, it was appealed at the CJEU by the European Commission. Few interesting observations were made by the CJEU. So they were as follows. The CJEU found that the GC erred in affirming the applicability of the arm's length principle in this case. The CJEU observed that since the arm's length principle is not a freestanding principle of the EU law, the EC's dependence on it for identifying the reference framework for state aid selectivity analysis is only justified when this principle is integrated into the relevant national tax law. Similarly, the CJEU stated that the OECD transfer pricing guidelines were not relevant to the transactions as there was no clear citation of the guidelines in Luxembourg tax law at the time. As a result, the CJEU ruled that the General Court judgment was based on an incorrect determination of the relevant reference framework. However, the CJEU upheld the General Court's annulment of the EC decision because the reference framework was incorrectly defined and not due to the reasons given by the General Court. So the CJEU ruled in this respect that the European Commission erred in recognizing the arm's length principle as if it were an autonomous principle of the European Union law that applies regardless of whether it is incorporated into the national law or not. It was noted that to use the arm's length principle for assessing the existence of a selective advantage under Article 107, Sub-Article 1 of the Treaty on the Functioning of the European Union, national law must explicitly reference this principle. According to the CJEU, the European Commission employed the OECD transfer pricing guidelines without substantiating their complete or partial formal adoption in the Luxembourg's legal framework. So this approach contravenes the prohibition against considering the external parameters and guidelines, such as the OECD transfer pricing guidelines, in the evaluation of a selective tax advantage under Article 107(1). Such external guidelines are not to be factored into determining the tax burden of an enterprise unless explicitly referenced by the relevant national tax system. So, in effect, the CJEU upheld the General Court's annulment of the European Commission's decision. So, a few key takeaways which are coming out of this judgment is that this present CJEU judgment, it reiterates that the foundational aspect of any selectivity examination under the EU state aid rules is the national law, which is as defined by the respective EU member states. Consequently, the EC is not permitted to introduce external elements or general principles into the selectivity analysis. Hence, the judgment, it aligns with the earlier Grand Chamber judgment of the CJEU on the NG and the CIOT cases. Another similar state aid case ruling by the top EU court is awaited in the case of Apple Inc., which people in the international tax space are keenly following. It will be really interesting to see what is the outcome of the Apple Inc. ruling. So that's it in this particular case. If you like the video, do follow and like my channel for more similar updates. Thank you.